Does the at-will doctrine stop you from suing an employer? Imagine losing your job suddenly and wondering if you have any legal options left. You might have heard about the at-will employment rule, but does it really block your chance to take legal action? Let's clear that up. The at-will employment doctrine is the rule that most jobs in the United States follow. It means either the employer or the employee can end the employment at any time, for almost any reason, or even no reason at all. This sounds like a free pass for employers, but it does not mean you cannot sue them. There are many situations where you still have grounds to take legal action. For example, if your employer fires you because you filed a workers' compensation claim after an injury, that is illegal. This falls under the public policy exception, which protects employees from being fired for reasons that violate state laws or public interests. Similarly, if your employer promises job security in writing or through consistent behavior, and then fires you without cause, you might have a case based on implied contracts. These contracts create a reasonable expectation that your job is protected unless there is a valid reason for termination. Another important point is that federal and state laws prohibit firing employees based on discrimination. If you are fired because of your age, race, gender, disability, religion, or retaliation for reporting illegal activities, you can sue under laws like the Civil Rights Act or the Americans with Disabilities Act. These protections exist regardless of the at-will rule. Sometimes, employment agreements or contracts specify how and when you can be fired. If your contract states you can only be terminated for cause, then the at-will rule does not apply. Breaching this contract gives you grounds for a lawsuit. So, even though the at-will doctrine gives employers broad discretion to end employment, it does not make them immune from legal claims. If your termination violates public policy, breaches a contract, or involves illegal discrimination, you can pursue legal action. Always remember that disclaimers in employee handbooks or employment policies do not override these protections. In the end, the at-will employment rule is a default setting that allows easy termination, but it does not prevent you from suing if your rights have been violated. Knowing your legal protections can help you stand up for yourself if you face unfair treatment at work.